Welcome back to the KLF Deep Dive. Let me ask you something. When was the last time you actually read your physician employment agreement, cover to cover? If you're like most clinical trial site leaders, you've probably glanced at the salary line, maybe checked the signature box, then moved on. Here's the problem. Hidden inside those pages can and probably is language that leaves your site vulnerable. And I'm talking financially, legally, and operationally. In other words, your PI agreement could be a ticking time bomb just waiting to go off. Today, we're going to unpack some reasons why that is, what to watch out for, and how you can protect yourself. So let's start with the first one. It's where everyone stops reading. It's basically compensation. Obviously, we all know you want to keep physicians happy, but structuring payments the wrong way could land your site in regulatory hot water. Think about bonuses tied to patient enrollment. This may sound like a smart incentive, but it can trigger concerns about inducements, about kickbacks, or even fraud allegations. Something I see very, very commonly is the idea of using percentage or splits. You keep this percentage, I keep this percentage. But it's a common area for enforcement for both state and federal authorities. It is a potential violation of the anti-kickback law. What is the big takeaway? We want to focus on efforts, not on results. So pay fair market value for time. There are exceptions in the anti-kickback law, for example, for the services exception. You want to look at expertise, you want to look at oversight, and you want to pay based on that. Incentivizing payments based on the number of subjects enrolled, or even worse, subjects who actually complete the study. Looks like you're buying data or even putting patients in harm's way, and that is a problem. The next one to think about is who actually owns the data. This has come up for me with a couple of different clients. And what's interesting is that the PI thinks that since they are the investigator of record and your contract is not explicit, the PI would argue that the trial data belongs to them. I've had this happen more than one time. That's not just a theoretical risk. These are real cases where departing PIs walked out of the door with data sets, patient lists, and with publication rights. What you want to do is you want to spell out that data and study records belong to the site. The physician's role is to generate and oversee that data, but the site should hold the rights to retain, access, and transfer it to the sponsor. Otherwise, you have a standoff when it's time to close or transfer the study. Now let's talk about non-competes and moonlighting. This is a high risk area. If you don't have the right restrictions, nothing stops a physician from going across the street and running the same exact study. On the flip side, too strict of a non-compete can make your agreement unenforceable, and multiple states and even the FTC are cracking down on this. If you look at what the Trump administration is doing, they have come out and said that they are not big fans of the non-compete provisions. This balance is tricky. You want to protect your investment in training, in infrastructure, sponsor relationships without locking your physician down in a way that will have the courts reject these limits. So what do you want to do? Your non-compete must be narrow, must be specific, it must be tied to your legitimate business interests. This means restricting the PI from competing in the same geographic area with the same study population, but not from practicing medicine in general. Another area, exit strategies. Too many sites use cookie cutter employment agreements. They're the standard ones, but they do not consider the unique compliance risks in research. For example, what happens if your PI loses the medical license? What if they get excluded from federal programs? Or what if they're under investigation?
Enjoying our content? We'd love to hear more. Please like, comment, share, and find more.
If your employment agreement does not give you the right to terminate immediately under those circumstances, you might find yourself stuck with an investigator who threatens your site's reputation and future studies. I've actually found myself helping clients in exactly this problem. Next. So what you want to do to avoid this problem, the termination clause should clearly protect your site from a compliance fallout. And that means that you include the right for termination in the case of loss of licensure, OIG exclusion, FDA disqualification, patient safety, non-compliance with study protocols, and others. Let's talk about how you want to protect yourself in the context of physician agreements, because they are foundational documents. They dictate your site's survival. The wrong compensation terms, unclear data ownership, weak non-competes, or vague termination rights, your PI agreement can become a nightmare, a legal and financial ticking time bomb. At the Kulkarni Law Firm, we serve as outside general counsel to review your agreements with clinical trial sites, if you're connecting with others, pharma companies, healthcare organizations. You know how to draft them, review them, negotiate these PI agreements, and you want to be compliant with regulations and keep your trials running smoothly. If you want peace of mind, if you want a second set of eyes, reach out to us at the Kulkarni Law Firm. Let's make sure that your agreements are shields and not time bombs.
Call, click, or email